We're ready to begin, Judge. Are you ready?
Yes, please call the case in.
On the Part K11 calendar, this part is now in session, and the Honorable Joseph Zayas presiding. Calendar 1, Indictment 1094 of 1994, Samuel Brownridge. Mr. Brownridge is present via Skype. All of the parties are via Skype today. Before the court, counselors, your appearances, please.
Donna Aldea, Barket, Epstein, Kearon, Aldea, and LoTurco for Samuel Brownridge.
Bryce Benjet and District Attorney Katz for the people.
Okay, and I know Mr. Brownridge is here as well. Good morning, Mr. Brownridge.
Your Honor.
And so good afternoon, everyone. This is a motion to vacate a judgment on a case that's been pending for a long time. It's a 1995 conviction, and there's been many efforts to vacate the judgment. And at this point, we've reached a point at which we can resolve the motion. So we're going to hear first from District Attorney Katz, and then Ms. Aldea would be heard, and then Mr. Benjet, and then Mr. Brownridge also wishes to make a statement, and then I will go on the record for a little while and give you the ruling, the court's ruling. So, District Attorney Katz.
Your microphone is muted.
The wonders of modern technology. Honorable Joseph Zayas, I want to thank you for the opportunity to present today to the court. I want to thank Ms. Aldea for her partnership in this with my administration. It's a young administration, but we're trying to do good work here. I want to thank Mr. Bryce Benjet for the work he's doing in the office. And Mr. Brownridge, I want to just acknowledge that we are here today in a joint motion to vacate this judgment. And I think it's important to note that it is joint. It followed a process by which this case was evaluated. The Conviction Integrity Unit in my office has been hard at work since January 1st on day one to make sure that we vacate judgments for those that were convicted wrongly, for those that we can only say we are sorry to, for those that we want to investigate to make sure that any claim of wrongful conviction does not go unnoticed and does not go not investigated. But this is a double tragedy here today. We now know of the innocence of this crime, of your innocence, Mr. Brownridge. But the actual shooter was identified as a man named Garfield Brown. And because he was not caught and because he was not prosecuted, he went on to commit other murders. And so the tragedy in all of this is great. I can only tell you, Mr. Brownridge, that we are working very hard here at the Queens District Attorney's Office to make sure that these claims are investigated, to make sure that we bring the best expertise to the Conviction Integrity Unit, to make sure that Mr. Benjet has the resources that he needs to move forward on these claims. I do want to note, though, it is a new day in Queens County, and I do hope that this is the beginning of a start to that when it comes to people who have been wrongfully convicted. We have new discovery laws that are now in place. It's too late to help on your particular case, but I do want to note that there are new discovery laws that ensure that important information, such as the identification procedures that were in this case, would be disclosed timely and would be very meaningful. We also in 2017 passed a photo array so that it would be blind and that we could administer it with more fairness and with more equity. So on behalf of the people of Queens County, this is a joint motion to vacate the conviction, the indictment, and to start really on a path of healing. So, Your Honor, I thank you, Honorable Zayas, for allowing me a few minutes of the court's time. We know that we are going down this path with quite a few cases. We have many investigations on the Conviction Integrity Bureau that we are following up on. And this is one crucial step to ensure reliability in the criminal justice system and hopefully to instill more confidence in the criminal justice system as we move forward. Thank you for the efforts of everyone.
Thank you, District Attorney Katz, for that important statement. I appreciate it. And at this time, Ms. Aldea, we'll hear from you.
Your mic is off, Ms. Aldea. Sorry, I swore I wouldn't do that, and then I did it too. Your Honor, thank you. At this time, based on the motion that I filed before this court, joined by the District Attorney, and on behalf of Samuel Brownridge, who I cannot be prouder to call my client, I ask that this court vacate this conviction on the grounds of actual innocence and dismiss the indictment. I'm not going to go through everything that's in the motion. I know that Your Honor has read it, and I think that it speaks for itself in many ways and is available. But I do want to make some remarks about what brought us here today and what can be taken from the lesson of this experience and this conviction. Samuel Brownridge stands before the court today, having served 25 years in prison for a murder that he did not commit. He was charged with this crime in 1994, although based on the information that was known to the police at that time, he never should have been charged. He was tried and convicted of this crime in the absence of any forensic or physical evidence whatsoever by a jury that never heard from his 3 alibi witnesses, that did not learn of powerful exculpatory information that seriously undermined the identifications that were made by the people's 2 sole witnesses in this case. While he sat in jail, his conviction was affirmed on appeal, with his constitutional arguments rejected because of procedural rules of preservation. At his first 440 motion, which happened 17 years ago, even after all 3 men who were with the shooter during this homicide came forward to testify that Sam was not involved and that the actual shooter was a violent felon named Garfield Brown, Sam's conviction was still allowed to stand. And on federal habeas corpus review, as Sam continued to serve his sentence, the federal court again denied his petition, citing procedural rules and deference to the findings of the state courts. In other words, Your Honor, as Samuel Brownridge stands before this court today, he is a man who was wronged, betrayed, and failed by our criminal justice system, which all of us have served for so long. He was betrayed by it and failed by it at every level, again and again and again. Building on this background, today is the direct culmination of 3 years of hard work, investigation, and unrelenting persistence in my firm's fight for Sam Brownridge. During this time, we poured through boxes of documents, transcripts, notes, and exhibits, and we unearthed new exculpatory evidence that had never been previously disclosed to the defense, to the jury, or to any court. We spoke to every witness we could find from prior proceedings, and then we didn't stop there, but we developed and discovered new leads, which conclusively proved Sam's innocence and established that this murder was actually committed by Garfield Brown beyond any possible shadow of a doubt. And I presented our proof and argued our case to the district attorney's office, who then admirably conducted their own thorough investigation and ultimately agreed that Samuel Brownridge is actually innocent. Today, after a quarter of a century, stop and think about that for a second. A quarter of a century, the truth has finally prevailed. While I am grateful for the unwavering dedication of Sam's advocates and supporters during this long struggle, and for the courage and integrity of the district attorney and her staff in finally recognizing and consenting to correct this grievous injustice. There is nothing that will restore the 25 years of Sam's life, the quarter of a century that were taken from him as a result of the deep fundamental flaws in our criminal justice system that this case so starkly reveals. In the spirit of cooperation between the defense and the prosecution that led to this exoneration today, it is my hope that legislators, judges, and attorneys on both sides of the bar will take the time to really review and really understand all of the multiple failures in our system that produced and then repeatedly affirmed this unjust conviction, so that going forward, we can work together to create and achieve a criminal justice system that is truly just for everyone. DA Katz stated that we've already embarked on this journey, that there are already reforms to our system that have occurred and that have been put in place, and that certainly is a start. But we're not there yet. We're a long way from there. I've been a lawyer for over 20 years, which is, I would note, not nearly as long as Sam endured prison. I've been both a prosecutor and a defense attorney, and I've taken great pride in my work on both sides of the bar. But my struggle for and with Sam is among the most meaningful accomplishments of my career. I really feel, Sam, that I'm blessed to have met you, and I think that you are such an extraordinary person. His grace and his optimism shone through every conversation that I have ever had with him over the past 3 years. And what strikes me most profoundly, and what I think is really the truest testament to the man that Samuel Brownridge really is that in spite of a lifetime of injustice and pain that he has been forced to endure because of a system that failed him at every level and at every turn, his spirit is not darkened by hate or by resentment. He is driven by hope, by love, and by gratitude. It's humbling. And I think that in the time that I've known him, as I've tried to put myself in his shoes, which I could never do. I don't think any of us can understand what he's gone through. But I keep coming back to that and wondering if I would be as good a person and able to overcome the negativity that this must have instilled and would instill in virtually any one of us. And it's a testament, a true testament to Sam, to say that he is the most remarkable person that I have ever met in this way. And I truly believe, Sam, and I've told you before, and I'm going to tell you now too, to you, that you're a better person than I think I could have been in your shoes. So accordingly, Your Honor, at this time, based on the motion that I filed before this court, joined by the district attorney, and on behalf of Samuel Brownridge, I ask that this court vacate this conviction finally on the grounds of actual innocence and dismiss this indictment. Thank you.
Judge, your mic is not on.
Thank you, Ms. Aldea, for your comments. And Mr. Benjet, hear from you at this time.
Thank you, Your Honor. I just want to briefly state officially that we are joining the motion to vacate on the grounds of actual innocence. The standard for actual innocence is set forth by People versus Hamilton, which is clear and convincing evidence that a reasonable jury would not convict. Under that standard, the court can consider all of the evidence that is at the trial, and as well as new evidence, regardless of any procedural barrier or evidentiary rule that could otherwise prohibit. The question is really about reliability. Here, we are proceeding on our own affirmation. Mr. Brownridge is proceeding on his counsel's affirmation. The court can consider all of the evidence before it. And I think the parties agree, and I hope the court finds that that does meet this burden. And then finally, as to the law, Hamilton says that the indictment will be dismissed as part of the court's judgment, but in an abundance of caution, we would move affirmatively to dismiss the indictment once the judgment vacating the conviction is entered. And then finally, just to Mr. Brownridge, I wanted to again extend our deepest apology for the failure that took place in your case. This was undoubtedly a failure of our criminal justice system. DA Katz has talked about some of the reforms that are already in place that would address some of the problems, but we will continue to strive to make sure that people in your situation and have that we're listening, and that we listen to these claims, we take them seriously, and that just as under the Hamilton standard, we reach through these procedural and evidentiary barriers to ultimately do justice, and that's what we're asking the court to do today. And again, we thank you, and we send our deep regret about the damage that was done in this case.
All right, Mr. Brownridge, I understand from Ms. Aldea that you would like to say something as well.
Yes.
I will tell you that I've already talked to Ms. Aldea and Mr. Benjet earlier today, and I've read their papers. And in reading the motion papers in this case, I definitely was kept up at night a few times, troubled by the things that were being alleged. And as much as I loved hearing from District Attorney Katz and Mr. Benjet and Ms. Aldea, the truth is I am most looking forward to hearing from you, sir.
Thank you. First, I would like to say thank you to my mother, who is no longer here with us. And not able to see me get exonerated today.
Mr. Brownridge, listen.
Yes.
We will take as long as time as you need. So if you need a moment, we will be patient with you and listen to you.
All right.
So don't feel like you have to rush through this. I know you just mentioning your mom was hard for you, but don't worry about that. We're going to listen to you. We want to listen. I want to listen to you. And I'm sure I speak for everybody on this call today. So if you need to pause, you need to take a break and take a minute, we'll wait for you, okay?
Thank you. Sure. First, I would like to say thank you to my mother, who's no longer here with us and not able to see me get exonerated. Thank you to my father, my wife, my 3 children who supported me throughout my incarceration. In addition, I am grateful for the support of my sister, my nephew, my nieces, my family, and friends that supported me and believed in my innocence from the very beginning. I would like to thank Bruce Barket, Donna Aldea, Danielle Muscatello, and Dawn Teller. You are an amazing legal team, and I will never forget your hard work and the opportunities that you afforded to me to clear my name. I don't think no one who's ever been incarcerated knows how it feels to be locked up, especially when they're innocent. I feel that the law enforcement has denied me the opportunity to make this right years ago. They lied to my face on record about my information that they received regarding my case. I sit down sometime. And I say to myself, why me? My 20s, my 30s, and half of my 40s are gone. I sit in my jail cell every night waiting for this day, while others went home to their families, knowing the system failed and the law enforcement did not do what they could do to free me as an innocent man. To many of you, this may look like a victory, but as I am before you today, I cannot help but see all the loss. But I also see hope. Hope for my future, hope for my family, and hope for reform. And all this time, I never gave up because I had to keep fighting for my family and because I know you have to keep fighting for what is right and what is true. The fact that so many people joined my fight to help this happen today, my friends, my family, witnesses that I don't even know, and my lawyers took on this case against the odds, prosecutors who admitted their errors, and now this court proved that there is not only hope for me, but hope for reform. And I want to thank everybody. Thank you.
Thank you so much, Mr. Brownridge. Judges are not supposed to cry in court, but that was very touching for me to hear. Mr. Brownridge, I was not a judge when you were convicted in 1995, or when you brought your motion to vacate your conviction in 1999 or 2002. Nevertheless, I am the administrative judge of this court now, the court in which you were wrongly convicted. And as the administrative judge, I do believe that it is important that I say how sorry we are for the miscarriage of justice, the grave injustice that occurred in this courthouse a quarter of a century ago. Mr. Brownridge, it seems to me, and some others have echoed this today, it seems to me that almost everyone in the criminal justice system failed you in some way or another over the last 3 decades, including the police officers who investigated your case and somehow failed to complete a police report which disclosed that the main witness against you identified another person in a photo array as the shooter just 2 days after the shooting, a person that we all know does not resemble you in the slightest. That is evidence of your innocence that the jury was not able to hear. Your original defense attorney, who failed to properly present your alibi defense at your trial. The trial prosecutor, who, it seems clear to me, failed to provide you and your attorney with critical evidence representing proof of your actual innocence, namely the main witness's identification of another person as the shooter in a photo array, a person who, again, did not resemble you at all, and again, the jury did not get a chance to hear that evidence, as well as the various courts, both state and federal, which heard your original motions and the habeas petition to vacate your conviction. Mr. Brownridge, the miscarriage of justice in your case is monumental, and it took way, way too long to discover and rectify. An innocent man is wrongly convicted, and it takes 25 years to discover the truth. You deserve better than that, sir. The obvious injustice delegitimizes our system of justice in the minds and the eyes of many communities. It is therefore no surprise that large segments of our city and our country have grave doubts about the criminal justice system and its ability to deliver equal and fair justice to all. Cases like yours, Mr. Brownridge, cases like this one, demonstrate that their anger is justified and their anger is legitimate. And I genuinely hope, being the hopeful person that I am, that all of the important stakeholders in our criminal justice system, the police, the defense bar, the district attorney's office, and yes, even the courts, are self-reflective and willing to look inward so that we can avoid these miscarriages of justice in the future and more quickly correct miscarriages of justice when they occur. Yet, as Ms. Aldea eloquently stated, in the face of this grievous miscarriage of justice, Mr. Brownridge, it seems to me that you never lost faith and you were lucky enough, or you were blessed enough to have the Barket firm and attorney Donna Aldea take up your cause. And as fate and good timing would have it, you were also blessed enough and lucky enough to have District Attorney Melinda Katz, who, to her credit, immediately created a conviction integrity unit, which, under the stellar leadership of Bryce Benjet, investigated your case and concluded, based not only upon new evidence, but also old evidence which had come to light, that you are actually innocent of the murder of Mr. Adams. Collectively, what they have done over the last 6 months on your behalf and on the behalf of the citizens of Queens County, in my view, provides a textbook example of how a terrible wrong could be made right and how a travesty of justice could be rectified. As the administrative judge, I thank District Attorney Katz and the Barket firm for their extraordinary work on your case and for bringing forth the truth about what actually happened to Mr. Adams, even as I recognize that this may bring little comfort or solace to the deceased family. And because I agree with them, Mr. Brownridge, that you are actually innocent, I hereby vacate your convictions and dismiss the indictment against you, and I wish you good luck, sir. Does anybody else wish to say anything before we proceed?
On behalf of the people of the state of New York, Judge, Mr. Brownridge, all the blessings that life has to offer to you, to your children, to your family. Godspeed.
Thank you.
Thank you, District Attorney Katz. All right, Mr. Brownridge, you want to say anything else before we sign off here? I mean, look, I think most of us are getting used to this virtual appearances, but especially a case like this, I would have loved to bring you into my courthouse, into my ceremonial courtroom, and grant the relief you requested. But this is not so bad. I imagine you're still at the comfort of your home, and I'm sure that if we were in a courtroom, the courtroom would be packed with people who love you and care about you and would be clapping right now. And as you know, there was a request to live stream these proceedings, which I granted. And I'm sure that's happening in other rooms across the city and the state. So thank you, everyone. The case is obviously the motion to vacate is granted, and the indictment is dismissed. Good luck to you and your family, Mr. Brownridge.
Thank you.
All right.
And Your Honor, with regard to sealing?
Oh, that's a good question. Right. So I don't know what other proceedings are being contemplated by the Barket firm or Mr. Brownridge. I'm happy to order sealing because the case is dismissed. However, if I can also order sealing subject to to these proceedings being transcribed to both the people and the defense. Ms. Aldea, what is your preference here?
Given the posture of the case and the fact that this is basically all the proceedings to date up until this point are public record and have been for the past 25 years, I would ask that at the moment sealing be deferred, and then I will make a motion for sealing at the time that that's appropriate, if that's okay with Your Honor.
Yes, that's perfectly okay. So sealing is deferred. We won't seal anything until I get a motion to that effect.
Thank you.
All right? All right. Thank you, everyone. I appreciate the time that you've given to this and your work on this again. And Mr. Brownridge, take care of yourself, sir.
Thank you. You do the same.
All right. Bye-bye. Thank you, everyone.
Thank you all.
Thank you.
Miss Aldea? Yeah. Can you just tell me the name of your firm again?
You're muted.
Your mic is off. Your mic is off.
Hello?
Your
I was
mic-
logging out. You just caught me. It's Barket, B-A-R-K-E-T, Epstein, Kearon, K-E-A-R-O-N, Aldea, A-L-D-E-A, and LoTurco, L-O-T-U-R-C-O, LLP.
Thank you.
Thank you.
Ms. Katz just signed back on, so I'm wondering why. See if she needs something.
I apologize. I thought I cut the judge off. Just wanted to make sure that we were finished and completed. Thank you, everybody.
We are indeed. Thank you so much.
Thank you.
Thank you.
All right. Thank you, Ms. Aldea. Thank you, Joan.
Okay, Barbara, see you tomorrow?
Yeah, I just sent you, one moment. For some reason,
Yeah.
I'm going to call you because I believe it's still recording.
Oh, okay, go ahead.
Why?